Welcome, everybody. Welcome to a warm afternoon here with us at Big Medium. We'll wait for a few minutes for more people to join us. In the meantime, I'm very, very excited to be able to work and to be able to just be here with power and with lovely weather, something that we can no longer take for granted here in Texas. So thank you everybody for joining us, and thank you Alyce and David. I'm very, very excited to have you both. For anyone out there, David has been a part of our team as intern and volunteer for probably over a year now, right, David?
Yeah, I think we're getting close to 2 years.
Yeah. It's just weird because last year I kind of don't count it anymore. But yeah, like a fully super active 1 year and then the weirdness of last year. But yeah, super valuable person in our team, someone that we love to hang out with, and someone that's always available and just willing to nurture and to it's really cool that we get to ask you random like law questions and that you're super kind of guiding us often. So yeah, it is lovely to have someone that we trust and it's part of our team leading this workshop. And David was kind enough to bring Alyce to us and showing this this workshop for us, and something that's so important and something that artists struggle with every single day. Like, and more, I'm sure like you'll tell us all about it, but when we see all of the work of different artists featured and the coasters and the like posters and whatnot, and now credit, and it's such a struggle and such a bad practice that I'm glad that you guys can shed some light on what are the good practices and what is that we should do in those cases. So anyway, I talked long enough. Thank you guys so much for being here. Thank you for guiding us, and yeah, just go ahead and tell us a bit of yourselves and what we're gonna talk about today.
Absolutely. Well, thank you so much for the far too generous introduction, Coca. It's been wonderful being a part of Big Medium for a couple of years now, and as long as you guys don't start locking the door behind me, I'll keep coming back.
Never.
But yes, I'm David Jenkins. I am a second-year law student at the University of Texas School of Law, and I'll let Alyce introduce herself.
Yeah, so I'm Alyce Zawacki. I have my own law practice called Alyce Zawacki Law. I've had my practice for about 3 years now here in Austin. I work with all sorts of creatives, visual artists, musicians. I've had a puppeteer client, interior designers. So really anybody in the creative space, I would say I've probably worked with that type of industry. And yeah, I'm excited to be here today. I've attended Big Medium events, and so I'm excited to speak with you all about copyright. I know it's an intimidating subject, so hopefully we can demystify it a little bit and make you all feel a little bit more at ease. With that, are we good to get going, or do you want to wait a few more minutes, Coca?
I think we're good to go. We are recording and we are broadcasting to YouTube. So if anyone, we'll get to start, and anyone can go back and see on YouTube or in our website whenever we post, if someone misses a little bit of the entrance.
Perfect. Sounds good. Well, I'll just give you a quick overview of what we're going to be discussing today. We are going to go over copyright law and kind of the basics of what really makes up copyright law in the US. We'll also talk about infringement and fair use. The fair use doctrine is something that I think is extremely misunderstood in the arts community. So hopefully we can kind of shed some light on that and what may be fair use and what maybe isn't fair use. Then we're going to talk about public art and moral rights. I know a lot of you are kind of in the visual arts area, so this is a very important act and gives you some additional rights in addition to copyright. So it's a great one for visual artists. And then we kind of have a little bit of a bonus subject matter kind of area. It's not quite copyright law. It's not VERA, which is the Moral Rights Act, but it's kind of something different and just kind of relevant to visual artists in general. And then we'll have times for some Q&A. You can post in the chat box if you have a question that you think of while we're going through. We will wait till the end to answer it, just so that we can get on with the presentation. But you can write it in there so that you don't forget what you were thinking about and don't lose track of thought. So let's start out with a general overview of what intellectual property is and why it's important for artists. Intellectual property is really the foundation that protects an artist's work. And then we also have, the brand side of it, where we have intellectual property protecting the brand. And so all IP is intangible. This means that you can't touch it or you can't see it, which is, I think, confuses people sometimes. But it is still really, really, really important. And as I said, it's really the foundation. It's what you're going to be able to use to go after somebody if they're infringing on one of your creative works or on your brand. Intellectual property fosters innovation, and it can be passed on from generation to generation like other properties. So you could leave your copyrights to your heirs. It may become more valuable in the future. We've seen this with a lot of artists that maybe didn't sell any artwork during their lifetime. And then upon their death, their artwork becomes really popular and sells and becomes very valuable. So it can become more valuable. It demonstrates ownership. So by registering, in particular, a copyright or your intellectual property, whether it's a trademark or a patent, you are demonstrating that you own that particular thing. And then it also protects about theft and unauthorized use, which is super important for all of us. So these are the different types of intellectual property. We have copyright, which is what we're going to be focusing on today. This protects original works of authorship fixed in a tangible medium of expression. I know that sounds very confusing, but we will get to what exactly that means in a minute. Then we have trademark. This serves to exclusively identify goods or services with a specific company. I have a lot of clients that come to me and say, I need to get a trademark on my canvas print, right? And they're definitely confusing that with copyright. And so I just want to point out, with trademark, we're talking about branding. We're talking about McDonald's and Nike and controlling the names of brands. Whereas with copyright, we're really talking about the creative works. So books, paintings, musical works. Then we have patent, and patent protects inventions and processes. Trade secret, which protects secret information. A really good example of this is the KFC recipe, right? Nobody knows about it. It's locked away somewhere. And then we have personality rights. These are kind of quasi-intellectual property rights, but pretty much it protects the use of a person's name, image, and likeness for commercial purposes. So you can't just use Elvis Presley to, go out and brand with something without getting his estate's permission. So I'm going to hand it over to David, and he's going to tell you a little bit about copyright and the basics.
All righty. So yeah, let's get started with copyright basics. If you want to move me one ahead, Alyce.
Sure.
Here we go. So starting with where we actually get copyright law from in the first place, it is derived from the US Constitution itself. There's a part of the Constitution we call the Copyright Clause that basically says it's a goal of the US Constitution and the laws of the country to promote progress and protect the expressions of authors. But the modern copyright law, as we know it, comes from the Copyright Act of 1976. If you remember Alyce just a moment ago talking about the whole idea of an original work of authorship fixed in a tangible medium of expression, that incredibly dense legalese comes from the Copyright Act of 1976. It's not a thrilling read, but it's an important read. It provides you with all of the exclusive rights that copyrights provide in the modern age. And we'll go into what those actually are in just a second. So first, what actually can be copyrighted? Remember that copyrights don't apply to the idea behind your work. They apply to a physical work itself. And that's where that sort of arcane sounding phrase that always comes up with copyrights comes from. So the requirements to be a copyrightable work start with first that it has to be an original work of authorship. This is a much simpler requirement than it sounds. It just basically means you had to have made a creative work. It usually just rules out the possibility of having something strictly factual or something that you already copied and provided no original work for towards a copyrighted work. The second being that there needs to be a minimal level of creativity, which isn't actually, a judgment by any court or the Copyright Office on the artistic merit of your work. It's a very low threshold just to show that there was some individual discernment on the creation of your work. You did have to think of something and actually create it. And then we have the third requirement, that something has to be fixed in a tangible medium. This is just the idea that a copyright protects the physical expressions of your work. So when you're making a painting, for example, it's the physical painting that you've made that is protected, not the idea behind the painting, not the concept within your head. You can only copyright something once it's actually tangible in some way. The idea being that as soon as the copyrighted work actually is physical, you've actually put the paint on the canvas or the charcoal on the paper or whatever it may be, it immediately has copyright protection because you have now fixed it in a tangible medium. That being said, there are a number of things that we cannot copyright, basically just trying to preserve copyright as the method of protection for creative works. So like Alyce was saying earlier, you can't copyright things like titles or brand names, slogans, corporate logos, etc., because those are meant to be covered by other areas of intellectual property law. So as long as you're not working with corporate work or company work, you don't really have to worry about them. But beyond that, you also cannot copyright useful designs or articles because those are supposed to be protected by patents, not copyrights, when they're more towards the practical rather than the creative. And most importantly, to keep in mind for artists is that you cannot copyright ideas, like I've said a few times, because it's a very important concept to get one's head around. Is again, it's only the physical expression of your work that is protected by copyright. No ideas are copyrighted, and that also includes that you cannot get copyright protection from general concepts or ideas that arise from nature. So you can't have a copyright towards making a painting of a bear because bears exist in nature and they don't belong to you. The idea of a bear doesn't belong to you. Or if you're making sculptures out of a certain metal, you can't copyright making sculptures out of that metal because it's the concept of making that sculpture. The physical sculpture you make in that metal can get copyright protections, but not the idea of making it, if that makes sense. So you know what can and cannot be copyrighted. What does a copyright actually do for you? I think the easiest way to think about it is that a copyright does exactly what it says it's going to do. It gives you the right to copy your work. There's more to it than that, but that's the basic principle. When you have a physical work, it's been fixed in a tangible medium of expression, you immediately have the copyright once the work's created, and it gives you the exclusive right to make copies of that work. No one else can reproduce the work or distribute the work without your say-so, or they're infringing on your copyright. So that includes, of course, the ability to authorize others to make those copies is your exclusive right as a copyright holder. The right to make derivative works is an important one for artists. That's making works based on your original. A common form of derivative work is an adaptation. So like if you have a copyright in like a book, the adaptation of that work into like a movie or a TV show would usually be considered a derivative work. And that's why you as the original creator of that first literary work have the copyright over who gets to do that and when. You also have the exclusive right to distribute your work, whether you want to sell the work, where you want to sell it, those all belong to you. And the right to exclusively publicly display and perform the work, if it's a performative work or if it's a displayable visual work. Beyond that, some couple of important things to keep in mind for copyrights are the duration of a copyright. These exclusive rights granted to you by the existence of a copyright on your work last for 70 years past the death of the copyright holder. So if you're the artist, you have the copyright for your work you have those exclusive rights up until you die, and 70 years past your death, those rights remain within your estate. So whoever your heirs are, designated legally or otherwise, that's how long they retain the exclusive rights. Like just this year, I believe The Great Gatsby came to the public domain because it's now 70 years past the death of F. Scott Fitzgerald. Finally, an important note with whether or not you own your copyright exclusively is the idea of joint ownership. That's the idea that if you make a collaborative work, like more than one artist working on the same final product, the default rule is that everyone participating in making that collaborative work jointly owns one copyright. You do not all have separate copyrights to your part of the work if the work was meant to be one collaborative, cohesive whole in the end. And when you have a joint copyright in a work with a number of other artists, you can all use that copyright unilaterally as long as you account for the other owners when you make money off of it, basically. Like someone else can license the work because they, as a copyright owner, have the right to do so, even if they don't ask the other joint owners, but the other joint owners have to be compensated for the transaction that led to licensing that copyright. So the first sale doctrine is an important part of copyright as well. What it means is that it provides the individual who knowingly purchases a copy of a copyrighted work from the rightful copyright holder with the right to sell, display, or do with what they will, essentially, of that particular copy of the work. It basically means that even when you sell a work to someone, like a copy of your work, that doesn't automatically transfer them your copyright to the work, but the specific copy that they own because they bought it from you, they can do with what they want. They can resell it, they can put it up in their own little gallery or in their own home, or they can get rid of it if they want to. In the United States, artists are not currently paid royalties on resale of their work, so you only get a say on the first sale, if that makes sense. One thing to note about the first sale doctrine is that when you've sold it, again, it doesn't give them your copyright, so they can't reproduce it, even though they can mostly do with what they want of the copy that you sold to them. They can't start making their own copies of it. That's not within their rights as someone who bought your work. All right, so I know a big thing, especially that happens here in Austin with the growing presence of a lot of larger scale companies coming into the city and hiring artists to do work for them and improve their image with the city, is the idea of what happens when you actually do work for hire. It's an important concept in copyright law that just because you made the work doesn't necessarily mean you own the copyright. That's because, as a general rule, if you do a creative work, if you know, whether it be a mural, a song, a painting on canvas, any form of copyrightable artwork, if you do it as an employee of someone else, typically the copyright belongs to your employer, not to you as the employed artist. There are some complexities and exceptions to this general rule. One of the most basic being that if you're an independent contractor instead of an employee, then by default, the copyright does usually belong to you as an independent contractor rather than an employee. But it's important to know whether or not you really are considered an employee or an independent contractor in the actual transaction you are talking about. Labels aren't everything. Just because you or both parties are calling you either an employee or an independent contractor doesn't automatically mean those are the rights you're going to get. It's important to look at the nature of your agreement and your work. And as one of my law school professors has put it to me before, a good test is simply if it looks like an employee and smells like an employee and tastes like an employee, it's probably an employee regardless of whether or not they're calling you an employee. Yeah. So again, work for hire is a really important thing to keep in mind when you're doing work, whether it be a mural on the side of a building or just being commissioned to make something digitally. But it's important to know sort of why the work for hire doctrine exists and what it's meant to do. The main idea from sort of the company perspective of why they would automatically be given the copyright instead of the person who actually made the artwork is it's supposed to, one, protect them with the investments they make in the art so that they have control over the work that they're paying for and that the work that they're having displayed in connection with their company. You want to make sure that the artists involved in that work can't just sell it out from under you or license it to someone else if you are a company. And again, once you've commissioned a work in some form or fashion as a work for hire as a company, you're usually viewing that work as now connected to your corporate image or your company image or your public presence, whatever kind of scale company the work for hire was done for. That's sort of the motivation behind work for hire, is that they have more control over the work that they're paying for and the work that's connected to them as a business. But of course, still from the artist perspective, you want to make sure that your work is not used in a way that harms you, your reputation as an artist. You don't want the company to suddenly associate your art with a position that you don't agree with or with a message that you don't agree with. So the work for hire doctrine kind of deciding when the company has the copyright and when you have the copyright allows you to know exactly how much control you have. So a couple of very important common misconceptions with artists and copyright law. One is that you do not have to register a copyright to own a copyright. When you make a copyrightable work, painting, sculpture, song, video recording, anything, as soon as it is fixed in a tangible medium, whether that be on the canvas, the sculpture is live, the recording is saved somewhere permanently, you have a copyright as soon as that work exists tangibly. It takes effect immediately, and so do all its protections. What copyright registration does is not give you a copyright, it makes your copyright enforceable. And I believe Alyce will be talking to you more about that later in the presentation. But again, you own a copyright if you're an artist. If you're an artist and you've made works, you already own a ton of copyrights. I guarantee it. Whether or not you've registered them. Registration comes in with actually enforcing your copyrights. Another is the idea of the poor man's registration of there's not really a clever workaround to actually paying the US Copyright Office the proper fee to register your work. Mailing your work to yourself does not give you copyright registration. If you want to properly and effectively register your copyrights, you do have to go through the US Copyright Office's registration portal, whether digitally or physically, pay the proper fees, fill out the proper forms. Finally, is that most people are familiar with the little C symbol for copyrights. Oh, I'm mirrored, I have to do the other hand. But that symbol does not inherently change anything about a copyright and whether or not it exists. You do not need to have a C symbol on a work to have it have copyright protections. Again, as soon as the work falls within the requirements for a copyrightable work and exists physically, it has its copyright protections. The little C symbol is a form of public notice. It's just an extra bit of notice that can make it easier if you're trying to enforce the copyright, or can put people on notice trying to deter people from infringing on your copyrights, but it doesn't in itself provide you extra protection as a copyright holder. So again, registering your copyrights is useful because it is how you enforce your copyrights. Under the current federal law for copyrights and copyright infringement, you can't bring a suit against someone for infringing on your copyrights unless you've already registered that copyright with the US Copyright Office. An important note is that you don't have to have registered it before someone infringed on your copyright. It's very helpful if you did, but it's not strictly necessary. But you do have to have it registered before you try to bring the suit. Registration beyond just letting you sue someone for infringing on your copyright, of course, also puts your ownership of the work and its copyright into the public record, which makes life easier for you as the copyright holder in a number of different ways, just from being able to show that a work belongs to you and have it be attributed to you, and make things easier if someone does end up infringing on your copyrights. It's easier to prove, look, this belongs to me the whole time. The world was on notice. This belongs to me. I deserve to have my rights enforced. Excuse me. The U.S. Customs Service will also protect against the importation of bootlegs. Having a copyright registered lets the U.S. government know that this work belongs to you and helps enforcement against copies that shouldn't be out there in circulation. Finally, again, you only have access to the kinds of damages, aka money, you can get from an infringement suit if you've got it registered properly. And that can be a big deal, since currently under federal law, you can earn up to $150,000 per work in just statutory damages, meaning just in their violation of your rights under the law, before you get to other kinds of money you can get back from a suit. But obviously, copyright infringement suits can have a very big impact on you financially and personally. So having the copyright registered, even beyond having it exist, makes it much more useful to you.
Great, thanks, David. So I'm going to be talking about infringement and fair use. So once you've got to a point, now you're probably thinking, okay, I actually own some copyrights. What can I do if somebody is infringing on my work and using it in a way that I don't want them to use it? So as David said, you've got these kind of bundle of rights. And I like to think of them as kind of a bundle of logs over here of all these things that you can stop people from doing with your work without your permission. So if anybody does any of these things, that's where we end up with infringement. If they don't have your permission to do it, then that's a violation of your exclusive rights, and you can potentially go after them and sue them. So what exactly do you need to prove? The first one is that you have to prove that you have a valid copyright. So it has to be registered, as David told you. That is a relatively new law. You previously didn't have to have a registered copyright, but you now do. So you have to go through the copyright registration process. That can take up to 10 months. So it's always best to do it before you have an infringement issue in front of you. Then the second thing that you have to prove is that the defendant copied protected elements or allowed somebody else to copy protected elements. So that second half of that sentence has to do with secondary infringement. So say you just said to someone, or there was an employee, and you said to one of your, you're the employer, you said to the employee, I want you to go out and just copy and take that artwork and use it for one of our products, right? That's you telling somebody to do something. So that's called secondary infringement, even though you didn't directly do the copying. So there's two ways that we can prove that somebody copied the protected elements. The first one is evidence of direct copying. So there's an exact copy of something out there in music. You know, we often see this where there's a song and then somebody else uploads it onto another streaming platform under a different name, right? It's the exact same song. That's really clear evidence of direct copying. Then we have this other thing where it might not be an exact copy, but there's kind of similarities between the artwork. And so in order to prove that copying has happened in that situation, you have to demonstrate that the person infringing actually had access to your work. And then you have to also prove that they're similar. So they can't be completely different. And there's a whole process that the court goes through to try and compare the works and see which elements were actually taken and how similar the works are in order to then determine, whether copying occurred. On the access front, if there's kind of a really obscure person that had something out there in the world from 50 years ago and nobody's ever seen it, it's going to be hard to demonstrate that the infringer had access to that work. On the other hand, if it's a really huge famous artist whose artwork was out there and people know about them and it's they've got products on Etsy being sold as merchandise and everything else, then access is going to be a lot easier to prove. The third thing that comes into play here as well is that the person who's infringing cannot have a valid defense as to why they were infringing on the work. So let's take a look at some of those defenses. The first one we have is the statute of limitations. So a lawsuit has to be brought within 3 years. It's a little bit funny with copyright law because that can potentially keep on renewing, because as soon as a new copy goes out, the statute of limitations begins again. So you don't have to be too worried about the statute of limitations. There's normally some workarounds around that. Then we have de minimis use. The use is so small and insignificant that the courts just say this isn't worth punishing. A really good example of this was a case where it was a TV series and there was a poster of somebody's artwork just in the background as set design. And the person who was the artist who had the copyright in the design of the poster sued the TV company, and the courts came back and said it was just in the background. Nobody was really concentrating on it. It was simply set design. And in that case, it wasn't worth punishing. And so they had a defense. There was still copyright infringement technically, but it just wasn't big enough to be an issue. Then the other one, we have permission. So if a license was actually granted and the copyright owner says to that person, you're allowed to use it in these ways, then there may be permission. That's a defense to a claim of infringement. And then we have this last one, fair use, which I'm going to get into kind of the nitty gritty of this, but this is the most commonly known and the most commonly misunderstood defense out there. Pretty much with fair use, it all depends on the facts of the situation. There is no bright line rule. I often have clients come to me and they say, I'm putting together this work. Can you tell me if it's fair use or not? It just doesn't work like that. I've read a million fair use cases and all of them, come out slightly different and are very fact dependent. And at the end of the day, I can't tell a client that. If somebody wants to sue you and take it to court, then a judge is going to have to rule on that, or a jury. So in saying that, if it does get to the point where it ends up in a court, there are some factors that the judge will look at. So we have these 4 fair use factors, as they're called. The first one is the purpose and character of the use. So what the court is looking at here is, was it a commercial use or non-commercial use? And was it transformative? Did they maybe add some elements that made it really different to what the original work was, in a way that, it's completely transformative and has a different effect on the people that are purchasing it? Then they look at amount and substantiality used. So we're looking at quantitative versus qualitative here. They really like to use this kind of saying the heart of the work. And so even though it may be just a small portion of the work that's being copied, if that is really the main focus of the artwork or the particular work at issue, for example, a song is a really good example. Maybe there is, the song is 4 minutes and only a couple of sentences from the chorus was taken. Well, the chorus is always going to be the heart of the work. And so that's going to be more towards it being not a fair use defense available. Then looking at nature of the copyrighted work. So if the underlying work is more factual, then that's going to be more likely to be fair use. If the underlying work is more creative, then it's going to be less likely to be fair use. Then looking at published and unpublished, if it is published, it's going to go more towards fair use. And if it's unpublished, it's going to go more towards not being fair use. And that's because the courts have this idea that if something is unpublished, the author hasn't really had an opportunity to take advantage of that work and get it out there and see how they can sell it before somebody's swooped in and started, infringing on their work before they even got to. Then effect on the market. This one really used to be the most important factor that the courts used to focus on. It's not really anymore. They focus on all of them now, and they really focus on this transformative test, as we'll look at in a minute. But effect on the market pretty much says, is the new work, the infringing work, is that a market substitute for the underlying work? So is somebody going to go out and purchase this new infringing work instead of purchasing the real work, the one that was infringed on? So, and licensing opportunities as well, what would they normally be licensing it, how much for? That all comes into play as well when looking at how much damage was done. So typical fair use categories, we have commentary and criticism, teaching and research, news reporting, and then parody, not satire. We'll look at one of these cases in a minute here, but this is a big one. So this case is super interesting. Graham versus Prince. Prince is an artist, an appropriation artist, as he likes to call himself. And so he has a series of work. This is just one of them, but essentially he takes other people's artwork and then he creates them into his own. So in this particular case, he was taking people's photographs. Some of them were from actual photographers. So this one on the left-hand side was from an actual photographer who ended up suing him. But some of them were just Instagram or photos that he found online that he then put into these kind of pictures that made it look like an Instagram post, and then did commentary underneath. So he's kind of commentating on, and you can't really see it in this one, but he's making a comment on what exactly is happening in the picture. And not all of them were, very valuable comments, but they were comments all the same. So Graham, who was the photographer of this particular picture, sued Prince. And he said, it's copyright infringement. He has taken my photograph. He's put them into this display. Mind you, Prince's work sell for hundreds of thousands to millions of dollars. And so he sued. Unfortunately, he did not win. The court came out and said that this was fair use. So they said that it's transformative. Somebody isn't going to come and buy Prince's artwork instead of buying the photograph. I don't know if I necessarily agree with that. A lot of these, court cases against Prince have come out in his favor. There was another one where there were only some slight changes made to some images. And so, it's kind of a fine line, and that goes to show where you can't always tell if it's going to be a fair use, legitimate fair use claim or not. Then we have this one, which is also a really recent one. So 2020 was just decided at the start of this year. We had "Oh, the Places You'll Go" versus "Oh, the Places You'll Boldly Go." And the creator of this one over here, Comic Mix, they tried to claim that this was a parody, that this was okay for them to do, even though it was, pretty similar to "Oh, the Places You'll Go." Even all the pages inside the book were laid out very, very similar in the Dr. Seuss style and rhyming language. In this case, originally, the lower court actually said that it was fair use and that this was okay to do. But then we had this new court ruling from a higher court at the start of this year, and they said, no, this isn't okay. It's not parody. It's really satire. And so when we're talking about satire and the difference between satire and parody, you have to really be making a comment on the underlying work. You have to be saying something about the underlying work and adding to it or commentating on it or criticizing it. Whereas satire, you're really just taking the idea and then making a completely unrelated message. You're not really saying anything about this other work. He's not commentating on Dr. Seuss or "Oh, the Places You Go" or making fun of it, really. He's just used the style and the language to create this new work in order to sell copies of it. So that one was not fair use. So as I said, there's really no bright line rule on when the fair use defense applies. And the only way to really find out 100% if something is fair use is to have a judge or jury deem it as fair use. So this would be fine if the average copyright lawsuit didn't cost between $384,000 and $2 million. This was from 2011, this report. I am assuming that it is much more than that now in 2020. So really, it's just not feasible for a lot of artists to be able to, defend themselves if they're claiming it is fair use, or to even bring an infringement claim. So what I always say is best practice is to get permission. Even if you think that your work is falling under the fair use doctrine, try your best to get permission. If you're still not able to get permission, reach out to an attorney so that they can really assess the facts of your case and let you know whether it's going to be a high risk case or whether you're probably pretty safe and it's probably going to be fair use. There may be hope in saying that. So at the start of this year, we had the Case Act, end of last year. I'm thinking we're still in 2020. I guess that's the year we've had, right? So the Case Act in 2019, it was originally brought to Congress in 2019. It is the Copyright Alternative Small Claims Enforcement Act, and it was finally passed just a couple of months ago. And so what this is actually doing is it's creating a small claim court so that copyright owners can file infringement claims for works under $15,000 or $30,000 per claim. This is going to be amazing for smaller artists because it really gives some teeth to claims that they're making. At the moment, when we send a cease and desist on behalf of a client, the other side can often tell that we're bluffing, that we're going to actually go to court because it's just so expensive and so time consuming that they know that the client's probably not going to do it. And so that can really work against you when you're trying to negotiate with somebody else. So this kind of changes things in that sense. Now we can say, well, you know, the client has the money to go to the small claims court and can enforce their copyright that way. There are some negatives kind of to this act. There is a 60-day opt-out period, which means that the other company could just say, I don't want to go to small claims. We're going to take you to real court. So that is kind of an issue and kind of concerning. We obviously haven't seen how that's going to play out yet, but hopefully not too many people do that. We have some uncertainty about who will determine the cases, whether it's going to be past judges or past attorneys or arbitrators. There's kind of some uncertainty on that at the moment. And it's also not going to create binding precedent. So that means that when one case is decided, it doesn't necessarily mean that another case that's decided in the small claims court has to follow it. So we may kind of end up with some hodgepodge kind of decisions that come out of the small claims court because they don't have to listen to each other. But aside from those, which I think are, you know, I don't think they're going to be a huge issue, this is really exciting, a really, really good thing for artists. I'll hand it back over to David for public art and moral rights.
Alrighty, so I know public art is especially huge here in Austin, and it's a good thing to know exactly what rights you have surrounding it. And public art can really be anything from statues you have up in the park to a mural you're doing on the side of a building to any form of street art. It's just art that's out there in the public. So let's get to it. Right, so there are, of course, some inherent risks that come along with putting your art out in the public. Can be trespassed on. People can go to where your art is pretty much any time because it's out there in the public. And you just generally have a lot less control over it since it's out there, open to the world. People can access it, they can photograph it, they can interact with it, they can harm it, usually before anyone can stop them. But that doesn't mean you don't have protections just because you put a piece of work out in a public space. Public works of art are just as copyright protected as the ones you create in your studio and display only ever on the wall of a gallery or in the middle of your own space. Oh geez, did we lose the presentation there for a second? Give us just a moment, folks.
Sorry about that, let me check.
Big hand for our pit crew, Coca Trevino.
Right, sorry, I think that was something on my end. Where on earth is it going? That was so weird.
Here we go again. Sorry about that, everyone. Considering all of Texas just thawed out last week, I'm surprised we made it this far.
Yeah, on my side, everything's just freezing at the moment. Okay, I think I've got it up. It's just loading very slowly. Can you see my screen now?
No.
Let me try and do it myself. Give me a sec.
Here we go. I think you're back online, Alyce.
Okay.
Yeah, and I'll be ready with the presentation if something else happens. Sorry about that.
No, I think it's my end. My computer, see, it's not loading though for some reason.
Why don't we try and have Coca share the slides?
Yeah, that might be better. Oh. Hang on, we might have it. Okay.
All righty. Thank you for your patience, everyone.
Just get us back to where we're at. I don't even know if they're loading. Oh, okay, there we go. All right, there we go. Sorry about that, everybody.
No worries. Back to public art. It's a thing. And of course, as we said, there are some legal risks that go with putting your art into the public. But again, you still have plenty of legal protections to your art, even when you expose it to the wider world. It's still copyrighted. You still have those exclusive rights. And a lot more relevance to a lot of works of public art, especially those vulnerable to the elements and to people potentially having access to them when they shouldn't, is the Visual Artist Rights Act, or VARA, that we've mentioned a few times here throughout the presentation already. But it was a relatively recent, this was a 1990 piece of legislation that brought moral rights surrounding visual art to the United States in kind of the first big meaningful way. And we'll talk about what those moral rights are just in a second. A good example of the kind of things that can come up when you talk about putting your art out in public is the fact that you can't always have perfect access or control to who's using your art because it's out there in public where they can always access it. This happened not so long ago in a case with Mercedes-Benz. They were filming commercials and posting pictures of their cars around Detroit, around spaces where a bunch of murals had been put up on public walls. They'd been part of a program put on by Detroit. They were all painted by local artists, but Mercedes hadn't contacted any of the artists whose murals were appearing in the background of their ads. Some of the artists filed suit, claiming that their copyrights were being infringed because Mercedes was making use of their work without talking to them at all. One of the deciding factors of that case was the fact that, especially with street art and murals, there's sometimes differentiation on whether it's considered more like a painting or more like part of a building. And that can have a big impact on, sorry, I think you're scooting through the slides there, Alyce.
My thing is everywhere. Okay, sorry.
No worries. But ultimately, in this case, which is still pending, the artists are arguing that their works shouldn't be viewed as part of a building just because they're painted on the side of a wall. They're visual artworks. The artists painted them without input from the people who made the buildings. They should be protected like any other painting is. And when someone uses your painting in their commercial, they should pay you for it. Of course, the outcome is still pending, but hopefully it'll come out on the side of the artists and we won't have a big legal hiccup about using murals in commercials without talking to the people who should be credited for them. So VARA, as we've mentioned several times, is the Visual Artist Rights Act, and it's hugely important to anyone who has their art in the public. What moral rights as provided by VARA basically are the rights beyond your economic rights to your work. So when we talked about the exclusive rights that a copyright provides you with for, reproducing derivative works, all that good stuff, the moral rights are those designed to protect basically your reputation as an artist, your brand as someone who sells these things, and the integrity of your work, because it's a part of you and it's a part of your canon and it should be protected. VARA is, as the name implies, exclusive to visual arts. It has to be a copyrightable work. but other copyrightable works that aren't visual art pieces don't apply to VARA. This is specifically for visual artists. The main factor of whether or not your work as a visual art is qualifying for moral rights under VARA is whether or not is it of recognized stature, which has been up for debate as to what exactly what that means in plenty of courts around the country, but in its most general sense, it means that your work has been recognized either by the arts community or society at large as having notable stature and presence. People recognize the work, or people recognize the artistic value of the work. And you can see those are pretty subjective terms, which is why it can be tricky determining what exactly is a work of recognized stature under VARA. So when you have a recognized work under VARA, what it provides you with as specific moral rights are things like preventing misattribution, because it's your work, so you should be credited for it. And anyone either taking your credit away or trying to accredit it to themselves or someone else can be violating your rights under VARA. Preventing modification and destruction basically means that your work is protected against people altering it in ways you don't agree with, whether that be defacing it or destroying it, or even people just thinking they want to add things to it that aren't physically damaging, but to you have modified your work in a way that you don't agree with. To be a qualifying work beyond a work of recognized stature, of course, you have to be a visual artwork, paintings, drawings, prints, sculptures, the like. It has to be basically not mass produced. So 200 limited editions or less is the limit. Unlike a typical copyright, it does not last for 70 years past your death. It only applies to works published after 1990, so when the act was in effect, and it only is enforced up until the death of the artist who owns the copyright. So it doesn't pass to your heirs or your estate like a normal copyright would. Finally, you cannot get moral rights to a work that was done as a work for hire. You know, we talked about that whole doctrine earlier. If you're doing a work for hire, it doesn't have the same moral rights that you would get for other similar visual artworks. So I think one of the best examples and one of the most powerful examples of how VARA comes into play in the modern society of the US was that recently in 2018, the largest damages ever awarded, clearly some pretty big spanking damages, came out of a case in New York, typically called the 5 Points case. Which I think is also particularly relevant to artists in Austin, since we have such a vibrant culture of street art here in the city. To summarize the long, harrowing story of 5 Points, essentially there was a large, mostly abandoned warehouse owned by a man out in Queens in New York, who came to an agreement with a number of artists to basically let them turn it into their own art space. And they turned it into what people ended up calling the graffiti mecca. You can see the picture on the left is when it was in its prime. They had a whole system of residencies and artists who worked there, and a rotating schedule for who got to put their work up on what walls and when. People were coming from all over the country and even all over the world to come see it. It got a huge amount of recognition and was thriving as a spot for art. And then gentrification came through, as it so often does. And the owner of the property decided he wanted to put up some luxury residences instead. And the artists objected to his plan to demolish the building for a new one, claiming it would destroy their works, and filed a petition against him for violation of their VARA rights if he were to destroy it. In the middle of the proceedings, as you can see on the picture on the right, he whitewashed the whole building, covering up all of their graffiti and all of their street art, without giving notice to anyone. And then a short time later, he ended up actually demolishing the building. After the work was whitewashed and the building was destroyed, the artists filed suit under VARA for defacement and destruction of their work, like we just talked about. And of course, they ended up winning, which was not only a huge show in the US for how powerful VARA can be, getting them $6.75 million to all of the artists who filed the joint suit, But it also proved to be a big day for the arts in the modern US in general, because the judges very clearly and directly recognized street art as works of recognized stature under VARA, as a form of fine art that deserved recognition and protection under the law. Some other notable examples of VARA cases are right here. For one, we have an example of what could or could not be a modification that's unlawful under VARA. When we had a 9/11 sculpture that was site-specific, but ended up being moved to Connecticut without the artist's permission. And ultimately, in that case, even though the artist had intended for it to be displayed at a very specific location, the court determined that the moving of the site-specific work was not an unlawful modification under VARA. We have another famous case with Ryan Upchurch, a rapper who purchased a painting, although didn't actually end up paying for it before he took possession of it and shot it full of holes, and then had case brought against him for destruction of the work, which is still pending. And then finally there on the right, we have an example of misattribution, where there was a Holocaust sculpture that had the artist's name on the base of the sculpture. And later when it was restored, the artist's name was removed without talking to anybody. So you can see these are all examples of things that could potentially be VARA cases. And the idea still being that VARA is meant to protect your reputation and the integrity of your work as an artist.
Thanks, David. So now I've got a little bit of a bonus section, and we're going to be talking about subject matter legal issues. I know that most people that are joining us today are visual artists. So this really relates to kind of the work that you do and what you can actually portray in your artwork with or without getting permission. So there's 3 common subject matter issues that typically come into play. The first of one is brands. Can you depict a brand name or an image, a trademark on your artwork, or do you have to get permission from the brand before you go ahead and do that? The second one is people. So depicting somebody's name, image, or likeness. This is misappropriation, as it's often called, or portraying a person in a way that's false, which is defamation, or depicting something private about a person, which is breach of privacy. When we're talking about the artwork world, we're often talking about, maybe there's an image of somebody that they have drawn, and maybe they didn't get permission to draw that person. Then we're looking at places. So this is depicting famous or historic places. And so there are some restrictions on this. It's important to know that generally just taking photographs or video or making a drawing of an architectural building is not going to be copyright infringement, but there are particular properties that have restrictions. So for example, the Eiffel Tower or the Sydney Harbour Bridge in Australia, you cannot take photos or drawings for commercial purposes of those buildings without getting permission from the owners. When we're looking at all of these things, there's kind of like this line of continuum. And so at one end, we have where somebody's maybe just making a one-off image and they're drawing somebody or using a brand name within that one-off image. And then on the other hand, we have people who maybe are taking a brand name and then making t-shirts and slapping the brand name on the t-shirt, or have somebody's face, somebody famous's face, and putting that on t-shirts and selling multiple copies of them. So the more we're kind of down the end of it being a one-off piece, the more likely that you don't have to get permission and that it's going to fall under the First Amendment freedom of expression protection. On the other hand, the more commercial it is of the art that you're making, the more likely that you're going to run into issues in this area. So we have some examples here. We have the Grand Theft Auto case. So the video game maker actually had this strip club within their game, and it really resembled this real life strip club in LA called the Pig Pen. It was actually called the Playpen, so a bit of a play on the words, on the branding as well, and they included it in the game as part of the scenes where people can walk around and play the game. The courts actually came out on this one, and they said that use of this trademark in this way did not confuse, and it was protected by the First Amendment because it was within the body of a game. They weren't, nobody was going to think in some way that the pig pen was actually associated with Grand Theft Auto. And so in that case, it was okay for them to use it in this way. Then we have the Three Stooges case, and this case was a real doozy. So the court ended up ruling that this charcoal drawing of the Three Stooges was not okay, and that they had to have had permission from the Three Stooges or the Three Stooges estates to do this and to make this artwork. This was an interesting case because the courts didn't focus on the commercial aspects. So you know how I said there's that continuum, and the more commercial it is, the more copies you're making, merchandise, all of that sort of thing, the more likely you're going to be in a hot spot legally. Well, in this case, the court actually said that just the painting itself was enough to be infringement. Even though they were putting it on t-shirts and doing all of these other things that were more commercial, they said even if they weren't doing those things, then this wasn't okay because it wasn't creative enough. It looks exactly like the Three Stooges, and therefore it was, they had to have got permission. I always like to compare this case to Andy Warhol, who obviously is very famous for painting images of people and has never been sued for doing that, and presumably, had never got permission. In that case, I guess maybe the courts would be thinking, or people would be thinking, that it is creative enough. But in this particular situation, they said not creative enough. And so, they had to get permission, and they were infringing. Then this last one has to do with the subject matter, area that I was kind of telling you about. So particular properties have particular restrictions. In France, the Eiffel Tower, nobody is allowed to create merchandise of the Eiffel Tower. You can take photos of it, but it cannot be for commercial purposes. So if somebody wanted to draw a painting and the Eiffel Tower happened to be in the background, it's a one-off painting that they're going to go and sell, that's probably fine. It's probably more towards the First Amendment protection, and you're going to be okay to be doing that. But as soon as that painting starts getting printed on t-shirts and coasters, or somebody starts making, 3D reproductions like these little mini Eiffel Towers over here, that's really where you're getting into a blurry line and into an area that can get you in trouble. So again, best practice on this front is get written permission from the brand, person, or place that you're depicting in your art before you go ahead and use them in your artwork. Especially if your art is not a one-off fine art piece. If it's a one-off fine art piece, you're probably going to be okay. I'm not going to say 100% you're going to be okay, but you're definitely more on that safe side than if you were, selling it and making t-shirts and coasters and merchandise. All right, we have some fact scenarios that we just want to go through to see how many of you have been listening today. So what I'll probably get you to do is in the chat, raise your hand if you want to say yes as your answer. If you're saying no, leave your hand down. So the first one we have is, your work is featured in an art gallery exhibition. The gallery has wrongly identified your work as someone else's and refuses to fix the issue. Can you sue them? Hands up if you think yes. I can see a couple of hands raising. Perfect. So yeah, this one we have, the answer is yes. This would be under VERA. And so misattribution to your work, you haven't got a credit, the gallery hasn't given you a proper credit, so you would have some recourse. Of course, in this situation, from a practical standpoint, you'd probably just tell the gallery and they'd go and fix it. David, do you want to do the next one?
Sure. So second, we have you find out someone is selling coasters on Etsy with your drawing on them. Can you stop them? And I'm not sure I can actually, here we go. Yes, I'm seeing some hands go up. But yes, that means someone is making a derivative work of your copyrighted drawing. As long as your drawing is actually fixed in a tangible medium, they can't be just slapping it on another medium and selling it for their own.
So we'll go to the third one. You made a logo design for your employer while you're working with them. Upon leaving the company, can you take that design with you and use the design elsewhere? Who thinks yes? I don't see any hands raising, which is great. So that's probably going to be, well, definitely going to be a work made for hire. If the logo was made for your employer as you were an employee, then it's going to fall under the work for hire doctrine. Over to you, David.
All right, you create a piece of kinetic art that has 3 moving parts working together. You find out that the person you sold it to has sold the parts individually. Can you do anything? So I do see a yes. Remember, the doctrine of first sale is if you have sold a specific physical copy of your work to someone else, they then have the right to resell it. You might be in some territory of them, taking it apart and being able to talk about your VARA rights, but generally, if you sell a copy of your work to someone, they have the right to resell it.
Yeah, I'm getting my computer. So we are getting into VARA there with destruction potential and modification. So going to number 5, on commission, you create a mural for the city council. Can the city paint over the mural? Hands up if you think yes. We've got one person saying yes. So this one really depends on what you signed before you created the mural. Under VARA, you may have some rights if you didn't sign away your VARA rights. If you did a project with the city, most likely they're going to have you sign a contract that says it's temporary. We can do whatever we want with it. We can destroy it whenever we want. We can paint over it. So it depends on what you're signing with that one. David?
All right, can you make a print run of 500 Barack Obama posters to sell? And would you change your answer if you made only one? Didn't see anyone change. It's good. Like Alyce was just talking about, you can get in trouble for misappropriation if you take someone's image or likeness and make their work. So you probably want to avoid breaking Barack Obama posters unilaterally.
Right. And if you're making one as a fine art, you may be more safe than if you're making, 500 posters that you're then going to sell for commercial purposes. Number 7, but obviously permission is always the best policy. Number 7, you have been given a document by an art collector that includes a transfer of your copyright in the work. Should you sign it? I don't see any hands. So we're getting into work for hire territory here. Whenever an artist is seeing an assignment or of copyright or a work for hire language within a contract, that's really the time for you to stop and say, okay, I need an attorney to look over this and make sure that I've got the right deal and the best deal and not giving away too much.
All right, next, a company wants to license your work for reproduction on puzzles. The license states that it is a perpetual exclusive license. Is that something you should sign? Goes to no one for raising your hand. Saying something is a perpetual exclusive license is basically a fancy way of saying you're giving them your copyright. Again, labels aren't everything. Just because the agreement doesn't say formally that you transfer your copyright, if it says something like you give them a perpetual exclusive license, that's effectively exactly what you've done.
Number 9, you create artwork that features Barbie encountering funny situations. Is this fair use? Any answers? Andrew says yes, or one of our attendees. So this is kind of an iffy one, and it really depends on what exactly is going on within the artwork. And so Barbie or Mattel might come along and say, no, you're not allowed to use Barbie in that way. We own the copyright in Barbie and images of Barbie and trademarks in Barbie. But if you're kind of making commentary on Barbie or on Mattel, then you might be okay. But if you're kind of just putting her in situations and not really making any comment on the underlying work, that's where we're getting more towards satire, and satire does not fall under the fair use doctrine typically. So you want to make sure that if you're doing something that you are trying to make be a parody, it's actually a parody and not satire. All right, I think we've got some time for some Q&A. So
Thank you. Someone actually asked earlier, Andrew. Hi, Andrew. If it's free, you're the product. How's Google Arts and Culture platform making money from museums, art collections, and do the individual artists have any claim on this money?
Interesting. I don't think I've actually looked at this in detail, so I'd have to go see what exactly they're doing. I would assume, and David, I don't know if you know more about this particular platform, but I would assume that they would have some licensing agreement with the museums to be able to do this.
Yeah, I'm not any more particularly familiar with the Google Arts and Culture platform, but that sounds about right to me. And there's also, I mean, yeah, certainly when you're working with museums, such a large scale, you're likely to have some sort of agreement in place between the parties.
Right. Unless it's just a news report on the artwork, right? If they've just kind of, you've got maybe thumbnails and you can click on it and then go to their website or something like that, maybe it falls under fair use. But as David said, as soon as there's big museums involved, most likely they've got a license to cover them on that front. Any other questions from anyone?
One thing that I see, and you touched on it a little bit, but I can see a lot of artists struggling like with all this touristy things. And you mentioned it with the Eiffel Tower and with photos and stuff that people see in the street with murals. Can you tell us like very briefly and very simple words, like I've seen tons of murals of friends of ours or the artists that work with us that then appear in the coasters and the t-shirts and all kinds of merchandise around the city and being sold without credit, without any connection to the artist, and they're sold every single where in the city. Like what would you advise one of these artists to do when this happens?
Yeah, so I think with a lot of public art, there's still a lot of court cases that are deciding what is appropriate and what's not appropriate in these situations. From what I've kind of read, if you have somebody that's taking just a photo and posting it on Instagram and it's kind of, in that sense, then it's probably going to be okay in terms of the law. But then on the other hand, if you have somebody who takes a photo and then starts, selling t-shirts with that mural on it, or selling coasters, like you said, coasters is a really big one that I often see, where they've just taken a photo and then printed it and manufactured the coasters, right? In that case, we're really getting into that area of commercial and how that can be enforced kind of hasn't been too determined in the courts yet. But I would be telling my clients in that situation that they likely had a good basis to go after and stop the people from doing that, and say that, claim infringement for that kind of those kind of things and uses.
Thank you. So you and would we be okay by emailing you, for example, if someone's here present in the presentation or sees it later on YouTube, like would we be okay by emailing you about it?
Yeah, so you can definitely reach out to me through my website. It's probably the easiest way. We also have a really great resource in Texas called Texas Accountants and Lawyers for the Arts, which provide legal services. So that's a good resource as well for people, but you're definitely welcome to reach out to me and I'll see how I can help you out on that front.
Thank you. Also, Andrew asks, Richard Serra titled arc, if the city or whoever commissioned the piece sold the metal to a scrapyard, does Serra get some money?
So if the city, I'm not sure who commissioned the piece, sold the metal to the scrapyard. So we may have some Vera issues going on there if it was a sculpture of some sort and then they just took it apart and started selling it to a scrapyard. Vera probably could come in there. What do you think, David?
I think it's important to know who actually did commission the work and what the agreement between the parties was. Like if it's the city that tore it down and sold the scrap for money, it'd be an important question to answer would be, did the city commission the work? Was it a work for hire? Did they have the rights in it? Of course, that wouldn't be everything. But when you are talking about what happens to a public work like that, it's important to know right from the start who actually owns the rights in this work, because it's not always the artist.
Right, and as I mentioned earlier as well, with public art, if it's commissioned by the city, most of their contracts now are waiving rights to Vera. So they're making the artists say that they agree not to sue them under that act. So that's important to note as well.
Well, thank you so much for your time. We are very grateful that you took the time to explain to us a very, this very complex items and topics that we sadly don't touch on very often. So thank you both so much for your time, and thank you to our audience for being here. I'll share with you the resources that they gave us and their email addresses, their websites, so that you can be confident and be like trust someone. That's so important with these topics that are just nerve-wracking.
Absolutely. Thank you for having us, and I apologize for the tech issues on my end.
Don't worry about it. Thank you, David.
Thank you, Coca, for putting this on, and Big Medium for always being as amazing as it is.
Thank you, guys. Have a lovely evening.
You too. Bye.
Bye, everyone.